And I also, for those who may be here for Senate Bill 137, Pekarsky, that one will go by for the day at the request of the patron. The meeting of the Court Subcommittee on Criminal Law will come to order. Clerk, please open the roll. Members, please indicate your presence. Excellent. We have a quorum. The first bill on our, close the roll. The first bill on our docket is SB 18. Senator Locke, are you, catch your breath?
Thank you, Madam Chair. You've heard this bill before. It's been before this committee probably 3, 4, 5, 6, 7 times, several times, and it's been passed by both bodies and vetoed by the governor. The issue that we're facing here is children age 8 to 10 years who have been facing intake for delinquency, and we're criminalizing childhood. Senate Bill 18 will amend Virginia's juvenile code to clarify that children 10 years and under should not be criminalized and best served through existing systems of services. And that is essentially what this bill does. It's not any different than what we've done previously when this bill has been before you.
Are there any questions of the patron? I know that I will say to the patron that I see that there are several things that are good improvements as far as the safety of the public and the family, as well as the safety of the child, and also the clarification that all funding that would go to the child if they were treated as a delinquent follows this disposition. And I always like to say when you're 10 or younger, it brings it on home to me that the age that we're talking about.
Correct.
Are there any other comments? Is there anyone here to speak in favor of Senate Bill 18? Please come forward. We have just one speaker. Oh, two speakers? Two speakers. You may share 3 minutes.
Good afternoon, Madam Chair, members of the committee. We thank the patron for being so diligent with us over the years to continue bringing this bill back. And here we are hoping to get this bill that is going to decriminalize childhood across the finish line. Rise for Youth and the Virginia State Conference NAACP strongly support. We ask each of you to think about the children in your lives, whether they're your own personal children or whether they are children of family members, wherever those children are, that we recognize that a child 10 years old. And I also want to note that it's usually my granddaughter who is speaking. The first time she spoke on this bill, she was 8 years old. And this year she turned 12. And when she testified in the Senate on earlier, she said, you know what, guys, can we please just get this across the finish line? And so in the words of Zoe, can we get this across the finish line? Thank y'all.
Thank you.
Good afternoon. Sean Winetta speaking on behalf of the Humanization Project. Ms. Slater and her daughter put it perfectly well. I want to add to that. We ask you to support the bill. Thank you.
Thank you. Do we have anybody here wishing to speak against HB 18?
Good afternoon, members of the subcommittee, Madam Chair. I'm Beth Coyne. I'm with the Office of Executive Secretary at the Supreme Court of Virginia. We're not speaking against the bill in total at any way, so please don't misinterpret my appearance here. There's just a troubling aspect of it from a court process point of view at line 375. And we have addressed this with the patron. I will admit it was at the last moment, but what language that we were suggesting clarifies the court process in terms of who may be able to file a petition for a child in need of services if, in fact, a petition for delinquency is ever brought against someone who is under the age of 11. The policy of wanting to get services for those children is very noble. The process is not exactly clear from the current bill that you have in front of you. What we would submit is that the Commonwealth Attorney may be able to file a chins on behalf or against, it really is a process against a child in order to have the child declared chins and receive services, and we have offered language to that effect. this is in that way, the child would be able to receive the services that are available under 16.1278.4, which is the CHIN statute. It isn't really appropriate to go under the CHIN supervision statute because it's not a child that would be involving truancy or runaway, which is what is involved in CHIN supervision. So that's my sole reason for standing here. We're not opposing the policy of it at all. It's just this one clarification that begins at line 375 that we would like to clear up with the patron.
Thank you. We will get, if you will stand by, and we will get back to your questioning. I have several people online that I'd like to take testimony from first. We have two people who have signed up to speak for. The first is Amy Walters from the Legal Aid Justice Center.
Hi, good afternoon, members of the committee. I'm a parent of 3, including a 10-year-old, and Legal Aid Justice Center, and I'm a director of the Youth Advocacy Clinic at UVA Law. And in that role, I strongly support this bill, which I know you all know, to address the concern previously raised. My understanding of how this bill would operate in practice is that there would be no jurisdiction for a delinquency petition for children under the age of 11. And so right now, the CHIN statute does not define who can or cannot file a petition. It's actually open, could be law enforcement, could be school, etc. And so whoever, an aggrieved party, could file a petition for a CHINs for that underlying conduct for somebody 10 and younger, and only perhaps during the gap in which this bill comes into fruition would there be a circumstance where a child was charged who is under 11, and there's this time period in which the court is trying to figure out how to transfer that case into a CHINs case. This came up in the Senate hearing. But thank you very much for your support of this bill.
Thank you. And the next person who has signed up is Teresa Kimonos from the Human Rights for Kids. Teresa?
Thank you. Good afternoon, Madam Chair and members of the community. My name is Teresa Kamenos from Human Rights for Kids, here in support of SB 18 to establish a minimum age of prosecution for children at 11 years of age, because what child development and brain science tells us that children this young do not have the developmental capacity to form criminal intent. I just want to raise a couple of points that weren't already spoken about. According to data that was provided by the Virginia Department of Juvenile Justice between 2012 and 2024, 379 delinquency complaints were filed against children 10 years old or younger, with only 2% of those eventually being adjudicated delinquent. So the majority of the petitions are dismissed. And in recent years, states around the country, including Texas, Mississippi, Nebraska, Utah, Arkansas, and Louisiana, have all passed similar laws to establish a minimum age. And that list is not exhaustive. There have been several more. While Hawaii, Massachusetts, and Vermont all have set a minimum age of 12 years old. So states like Virginia, who currently don't have a minimum age of prosecution, are increasingly becoming an outlier in the United States. And so based on all of this and all of what has been said prior in support, we would encourage the committee to vote favorably on this. Thank you.
Thank you. If I could, before I know the patron wanted to offer something on what the Supreme Court concern was on staff, counsel, do you have any response on the questions raised about who should file, who can file?
More of a confusion, and respect Ms. Coyne from OES, so please tell me if I'm misunderstanding it. It looks under 16.1-260 that all petitions any matter that comes before the juvenile court has to be conducted by filing of a petition. Under subsection A, Romanet I, it says the attorney for the Commonwealth of the city or county may file a petition on his own motion to the clerk. It doesn't say that it's a delinquency motion. It doesn't say that it's a chin sup. It just says the Commonwealth attorney can already add it. So I'm a little confused on why we would add duplicative language to one statute when the 260 statute already controls for all the petitions. That's my only confusion. If that could be clarified for why it was necessary to be added to that one statute, it would be understandable, because I love a cross-reference. But
Madam Chair.
Yes, please.
If I could respond. That actually isn't the thrust of what our concern is. It's as the bill is structured at this point, it is upon motion of the Commonwealth, and then the judge would amend the petition to go from a delinquency petition to a chins petition. Now, you could conceive that at the point where a petition for juvenile delinquency is being heard in court, the child is possibly being represented by a public defender. But when an amendment is made to convert it to a chins, and frankly, I'm not even sure a judge can do that without an actual petition being filed, that public defender will no longer represent that child because they don't represent children in chins cases. It's a civil action, not a criminal action. So part of what we're proposing is that we clarify that an actual separate petition needs to be filed to allege that the child is a child in need of services. It just can't be shifting the juvenile delinquency petition and making it now a chins petition. That's not how it can work. And I fear that if this language is structured now in the proposed bill goes through, the judges will be like, I can't do this. I don't know how to do this. This isn't possible. And
do you have specific wording for us?
Specific?
Do you have specific wording that you
yes, we
believe do. Would you please present it to council? While we suspend for a moment, Senator Locke, is anything you would like to offer it on this point?
Madam Chair, my only, I don't have a problem with the amendment. My only concern is this bill has been out here for 3 years with the exact same language, that I've presented to here for you today, with some tweaks that we've made in response to the governor's vetoes previously. We've made some changes to accommodate that. But to be presented with an amendment at the 12th hour, just prior to my coming here today, is cause for concern, but I don't have a problem with the amendment that's being presented.
Thank you. And I would add to this, having been involved in this same issue just once, not the tenacity that the senator has gone after this with, that my concern is that we've got someone who is under age 11. Fact, under age 11. So I'm not convinced that there needs to be any separate filing or petition. They have been brought into the court for some reason by law enforcement. We know, the fact is they're under 11, and that triggers everything. So I'm not sure what the judge needs as far as permission. And then while I'm holding forth, my concern is, not having seen the wording, that if we put in that there has to be some sort of filing, whether or not that has spin-off on any other cases, where something that has been routinely done, now it is assumed that, oh, you've got to have a specific spelled out who files and where that filing goes. With all of that said, I'm now looking over at council as to how they have looked at the wording.
So Mr. Hatcher's trying to incorporate the language from OES as well as kind of clarify that if the child is under 11, a delinquency petition has been filed, that the delinquency petition would need to first be dismissed. We're going to add that, and then the Commonwealth may file a petition for a child in need of services under that appropriate section. So that would deal with the delinquency. It would get dismissed, so we were going to add language that would cover that and then allow the Commonwealth to file a chins petition if they so choose. I understand what OES is saying, because one's a criminal matter, one's a civil matter. Juvenile courts may think they don't have the authority to amend something from a criminal to a civil matter. I mean, we amend petitions to different charges, but not from criminal to civil. So I'm hoping that we can change this to make everybody on board with it.
And Madam Chair, if I may, with SB 70 and HB 438 that we've been hearing about sending these petitions back to CSU, some language was included about the delinquency petition being dismissed and expunged. under the analysis that OES has given, if counsel has been appointed to them and we're dismissing the case, we would want those charges to be dismissed and expunged because we wouldn't have wanted the child to be proceeded upon as delinquent. So I'm trying to add that language in as well. If you'll just give me like 5 minutes.
So that 5 minutes and/or in the interest of time, is if the committee's comfortable to act on the bill as amended to take care of these procedural issues, and we will actually carefully work out the amendments that you will see before full committee as we proceed, as we move the bill along. If that's all right with the committee, that's what I would propose.
Can I ask the patron a question? I just want to make sure that you've actually seen the amendments.
I've seen the
Senator Locke.
amendment,
Okay.
yes.
And it sounds like she does support it. It doesn't change what she's trying to accomplish. It sounds like more of a process thing than anything else. And so,
Yes,
very good.
I've seen the amendment, yes.
Thank you, Senator.
No, I'm assuming this is only procedural to make sure that nobody's left in a never land, unfortunate reference, but
Okay.
then we operate by motion.
Second.
So it's been moved and seconded that that I keep on saying H, it's a first meeting, SB 18 be recommended reporting with amendment. Any further discussion? Clerk, please open the roll. Members, cast your vote. SB 18 is reported with amendments by a vote of 8-2.
Thank you.
Thank you.
Madam Chair, if I may take a point of personal privilege.
Pardon?
I said if I take a short point of personal privilege on that last bill. I voted in favor of it.
I did not see your name before.
No, you're fine. I'm just mentioning.
Personal privilege, you are so recognized.
I'm just mentioning to the patron that I voted in yes, and we were discussing all the different amendments, and so we're following along, tracking what she's doing. So supportive in concept.
Yeah, it's it. But I do think that we're on the right wavelength, so I do not want to take it by for another week, another day. All right, with that then, the next bill on the docket is Senate Bill 23. I don't see Senator Salim here. Senator Deeds, Senator Stanley, you've been here for a while. You all decide. You're friends.
Okay, 713 is what happens when you wade into a dispute between your friends. Okay, Albemarle County built a new courthouse in Charlottesville, and the Albemarle County wants to ensure that the sheriff of Albemarle County wants to ensure that she can provide security in that courthouse. That's simply what the bill does. It was amended in the Senate because the Office of the Executive Secretary said it didn't do exactly what we wanted it to do. So, but it simply gives both sheriffs concurrent jurisdiction of security in the courthouse and on its grounds. The Albemarle County Sheriff does not have any responsibility in Charlottesville outside of the courthouse, but she has some responsibility in the courthouse. That's all the bill does.
Mm-hmm. And also, if something happens, she may proceed to apprehend the individual.
I think so, yes, ma'am. And she's supposed to be online, I think, if she's available to testify if you need her.
Are there any comments or questions? Personally, I thought given the number of circuit courts there are that have multiple jurisdictions, I would have assumed this would have been in the code before.
I think that it is when you've got an existing courthouse. What happened is they built a new courthouse in a new location, and so in the old courthouse she provided security. That her officers provided security, but the new courthouse, that's what this bill's about.
Is there anyone here to testify on this? You say she was not able to make it.
She's online, I think, or she was.
Is she on remote?
Yes,
please proceed. Sheriff Bryant.
Yes, hi. I'm Sheriff Bryant of Albemarle County Sheriff's Office. In 2019, when the county and city agreed to build that county district court in the city of Charlottesville, the General Assembly granted that permission, but it was never determined of who would provide security for that building. So with Senator Deed's help, this legislation was introduced to ensure that the county sheriff will provide security, courthouse and courtroom for district courts that sit in the city of Charlottesville by Code of Virginia.
Thank you. Are there any questions of the sheriff? Any comments from council? We operate by motion.
Okay.
It's been moved and seconded that we report Senate Bill 713. Seeing no other comments, clerk, open the roll. Members, cast your vote. And Senate Bill 713 is reported unanimously. Thank you, Senator. Now, Senator Stanley. And Senator Stanley, you have Senate Bill 106 before us.
I do, Madam Chair. And I believe that I've spoken with council and we have a little bit of a nip and tuck to that, do we not?
Yes, Madam Chair, members of the subcommittee, these were just handed to us, but they are very straightforward. If you look at line 12, we would be striking the words sodium or tianeptine sulfate. So the definition would just say, for the purposes of this section, tianeptine product means a product that is marketed for human consumption containing any amount of tianeptine. The second amendment would be adding a new subsection D that states the provisions of this section shall not preclude prosecution under any other statute.
Thank you. And is there a motion on the amendments as reported?
Motion to amend.
Second.
All those in favor say aye.
Aye.
Opposed? So that basically brings it in line with the code and the way in which the code treats Schedule I and other such prohibitions.
Taking the word sodium or tianeptine sulfate did give less heartburn of what was the tianeptine product. So by just blatantly saying it's any product that has the tianeptine in it, that's very straightforward.
Very good.
Yes. Madam Chair.
Please proceed for presenting the bill as amended.
Thank you, Madam Chairman, members of the committee. Senate Bill 106 tries to address a problem that we're having a lot of in the rural areas at our convenience stores, but also in our urban areas as well. Tianeptine was, by this body and by a delegate, put on the Schedule I list. One would think, okay, now it's illegal, so that takes care of that. But quite frankly, tianeptine is still being sold at these convenience stores, and it's known as gas station heroin. It falls under names like Jaja, Tiana, Neptune's Fix. And this is an opioid mimic drug that's highly addictive with severe withdrawal symptoms comparable to opioid withdrawal. Poison control centers nationwide have seen a 3,000% increase in tianeptine-related calls. People have died from this drug, and yet what we're seeing is, even though we made it illegal, we're not, the only way we're going to take them off the shelves is by putting it to the convenience stores, that they're going to be held responsible. A lot of our convenience stores and the law enforcement that I've talked to have found that the owner of the convenience store may be out of the country a lot. And the clerks are the ones left holding the bag. So what this tries to do is tries to teach them by penalizing them in an amount of money that will pull these very dangerous drugs off of our shelves. Our kids are ingesting them. They're getting sick. We have people that are trying to get over their own heroin or opioid addiction, and they are now becoming hooked on this horrible, horrible drug. And so this tries to address this once and for all so we can get this horrible drug off the shelves. And that's the bill, Madam Chair.
Thank you. Very straightforward. Is there any comments from the committee? If not, is there anyone in the room wishing to speak for Senate Bill 106? Anyone here to speak against Senate Bill 106? And there's no one online?
Move to report. Second.
Been moved and seconded that we report Senate Bill 106. Any comments? Clerk? As amended. Thank you, Porton. As amended. Clerk, please open the roll. Members, cast your vote. Senate Bill 106 reports as amended unanimously by a vote of 10-0.
Thank you, Madam Chair. Thank you, members of the committee.
Thank you for your patience. And I believe we have Senator, is it Mulkey? Mulkey. Please come forward, Senator Mulkey.
Thank you, Madam Chair. I have Senate Bill 776. And Council recommended a nice little change to the bill that I agree with. Should I tell you about that little change before we proceed? Madam Chair?
Please.
Do you want to?
I can. The senator also has it in front of her just because we did work on it. In talking to Ms. Paulus, we were a little bit confused on what the word relief meant. Was that a monetary relief? Was that relief from probation obligations? Or, just clarifying that. So we're going to change the language to say, absent any specific finding to the contrary, the court shall dismiss any such alleged breach of probation, and then add a sentence that says, however, such fines and costs shall remain due until paid, and all methods of payment and collection already in place to satisfy or collect any outstanding fines or costs shall remain available to such court after such dismissal. In case that sounds familiar, that is language that I pulled from HB 331 from Delegate McClure. That was about deferred dismissals without letting them be convicted just because they hadn't paid their fines and costs.
Thank you. Are there any questions about the amendment as reported?
Move the amendment.
Second.
All those in favor say aye.
Aye.
Opposed? Okay, now you may speak to the bill as amended.
Okay, thank you, Madam Chair. So this bill, under current law, failure to pay fines and costs can be considered a breach of probation. This bill ensures that failure to make payments that an individual owes on probation shall not by itself be deemed a breach of probation unless the court finds that the defendant was willingly refusing to pay. So this doesn't happen in my district, so I found out when I was checking around, but there are localities where if someone owes fines or fees when they're out on probation, it can some people will end up going back into incarceration, like into jail or prison, for not paying the fines and fees. This has nothing to do with restitution, which it says so in the title, but it does not. This is just for fines and fees. And so we didn't want people going back into prison or into jail just because they have a difficulty with their fines and fees, because of financial difficulties when they're out there trying to rebuild their life and start over. So this will prevent that from happening unless they're just unwilling to pay. If they have a real reason for not being able to pay, then this would prevent them from being reincarcerated. It doesn't mean they don't pay the fines and fees, but it means that they'll be able to set up some other method, whether it's delayed or whether it's a payment plan or whatever, but this will give them the ability to work on that instead of just, going back and, delaying a start over or, their ability to work and become a productive citizen in society.
Thank you. Are there any questions of the senator? We've had several bills along this line on the House side. So.
Yes.
Seeing no questions, does Council have anything to share before I turn to the public? Is there anyone in the room wishing to speak in favor of Senate Bill 776? Please come forward. I see 3 individuals. If you could split 4 minutes, please.
Good afternoon, Chair Watts, committee members. I'm Scott Payton. I'm the Director of Government Affairs at Prison Fellowship. Prison Fellowship serves men and women in 6 prisons here in Virginia, and we work in over 1,100 prisons nationwide. I served as a probation and parole officer in Louisiana for a little over a decade. I understand the importance of probation in holding people accountable, and also understand the importance of probation in helping men and women further their lives, work through reentry, and return back to their communities as productive citizens. And Senate Bill 776, which we support, preserves judicial discretion. It holds individuals accountable when non-payment is willful, and it reflects a fair and proportional approach to supervision. It ensures that incarceration is reserved for behavior that warrants it and not for circumstances driven by economic hardship. So I would appreciate your support of Senate Bill 776 and appreciate Senator Mulcahy's leadership in this area. Thank you.
Good afternoon, Madam Chair, members of the committee. Sean Winneto speaking on behalf of the Humanization Project. We appreciate the patron for bringing the bill forward. Members of this committee have done a lot of work on making the parole system or the probation system a lot more friendly towards transition and returning home. Obviously, speaking from my own experience, it's expensive to get out of jail. And if you're cycling in and out, you're having to constantly put down payments on things, purchase new clothing, all these different sorts of things makes it even more difficult to be able to make the payments that you need. So we do appreciate the patron bringing it forward. This is just another piece of the puzzle, a lot of the valuable work that members of this committee and the body as a whole have been doing, and we ask you to report the bill out. Thank you.
Good afternoon, Madam Chair, members of the committee. Chuck Mayer with Reform Alliance. For the reasons previously stated, we support the bill.
Thank you. Is there anyone here speaking against Senate Bill 776? Seeing no one wishing to speak, we operate by motion.
Move to report as amended.
Second.
It's been moved and seconded that Senate Bill 776 as amended be reported. Clerk, please open the roll. Members, cast your vote. Senate Bill 776 reports with amendments unanimously 10-0.
Thank you.
Thank you, Senator.
I just want to say thank you for that. As a 30-year survivor of domestic abuse, you will normally see me in front of this committee advocating for victims, but I am desperately searching for a way that I can also work with perpetrators in rebuilding their lives, and this is a way that that I feel like I can help those as well. So I appreciate your support on this bill.
You have several people who have done a similar devotion to the issues that you referenced.
Thank you.
Not seeing Senator Salim in the room, I'm going to, since it's our first meeting, put it off, and seeing no other business before us, the meeting is adjourned.